The topic which was given by organizers of the BYC to me was what does international law say about fencing of Gwadar? I have little bit modified the topic with my questionnaire with this, and a little bit changing. I have put it in this topic that title the fencing of Gwadar and analysis of international law and its implication on the current situation. For a better understanding, we have divided the topic into 6 outlines. The first part of the paragraph is opening paragraph, and the second would be the introduction and recognition rights and indigenous peoples of Gwadar over land, territories, and resources, including marine space and marine water. The third would be the Gwadar fencing, violations of international human rights and the international humanitarian law. The fourth would be the outcomes of such illegal fencing and forceful dispossession of indigenous people over their land. The fifth part would be the instruments of international law and way forward. The sixth would be the future is ocean and would be also my concluding paragraph. Shall we start? The fencing of Gwadar port city in Pakistan has raised concern about the impact on the indigenous people, indigenous Baloch population, and the legality of the project under international law. This paper examines the international legal framework applicable to the fencing of Gwadar, including the rights of indigenous peoples, the principles of self-determination, and the protection of cultural heritage. It argues the fencing of Gwadar which violates the international law. This paper relies on a critical analysis of international legal instrument, policy documents of UN, and research papers on law of sea on convention. It examines the Pakistan government's obligation under international law and the impact of fencing in Gwadar on Baloch people. The second part of the topic is the introduction, recognition, and rights of indigenous peoples of Gwadar over land, territories, resources, include marine space and marine water. At the core of indigenous people's struggles are their rights to land, territories, and resources. Ancestral lands are the source of indigenous people's cultural, spiritual, social, political identity and the foundation of traditional knowledge system. The former Special Rapporteur of UN Martinez Cobos elaborates that indigenous peoples' lands and identities are the interwoven and inseparable is of a particular significance. For instance, the World Bank considers as a key features of indigenous peoples collective attachment to geographical distant habitants or ancestral territories. The Food and Agriculture Organization of the United Nations, FAO, views as indigenous and tribal peoples population identity is of fundamental importance to indigenous people who see their livelihood, security, well-being, and dignity as being inextricably inseparable linked with the preservation of their ancestral lands and territories. In their understanding of indigenous people, both organizations emphasizes that connection to land like Kobo, FAO explicitly connects indigenous peoples with identities with their historical lands. Article 25 of the United Nations Declaration on Rights of Indigenous Peoples affirms that indigenous peoples have the right to maintain and strengthen their distinctive spiritual relationship with their traditional, owned or otherwise occupied or used lands, territories, and resources to uphold their responsibilities to future generations in this regard. For the most part, indigenous peoples have managed to maintain at least the core features of those societies to present day, despite colonization and other hardship. I would like to read this paragraph again. For the most part, indigenous people have managed to maintain at least the core feature of the societies to the present days, despite colonization and other hardship. For these reasons, one early focus of the International Indigenous Corpus Juris was to allow indigenous peoples to maintain and develop these societies to exist side by side the majority society. Together, these principal norms could be described as a foundation of international indigenous framework. Here, the topic was assigned that by VYC. I put it to the questionnaire of that. This is my paper, which would be the what does international law say about fencing after all these indigenous rights and over land, territories, and resources. Gwadar fencing, violations of international human rights law and international humanitarian law. Any measure Pakistan undertakes in the Balochistan in the name of security must comply with its obligation under international law. The construction of fence wall inside the Gwadar violation violates the both international humanitarian law and international human rights law. Two sets of the complementary legal framework apply to Pakistan conduct in the fencing of Gwadar: international humanitarian law and international human rights law. What does international humanitarian law say about that? According to international law, an occupying power is required to administer the territory it controls as far as possible without making far-reaching changes to the existence order. I would like to read this paragraph again. According to international law, an occupying power is required to administer the territory it controls as far as possible without making far-reaching changes to the existing order, while at the same time ensuring protection of fundamental rights of inhabitants of native people of territory. The core idea of international rules of belligerent occupation is that occupation is transitional for a limited period, and one of its key aims is to enable the inhabitants of an occupied territory to live as a normal life as possible. Article 53 of the 4th Geneva Convention prohibits the destruction of occupying power of private property or public property. Article 147 of the 4th Geneva Convention lists as a grave breach extensive destruction and appropriation of property not justified by the military necessity and carried out unlawfully and unwarrantedly. Moreover, measures of collective punishment by the occupying power are forbidden by Article 33 of the 4th Geneva Convention. For almost one decade, Pakistan has repeatedly violated international law by its continuous construction and expansion of mega projects inside the Gwadar of illegal settlements of Chinese investors and related mega projects infrastructure without prior consultation and consent of people of Gwadar. Notably, the extensive network of Gwadar roads under China's Belt Road initiatives of CPEC and aim for securing Chinese investment and large areas around mega projects designed as the security areas. The construction of the fence wall inside the Gwadar is such a measure. Routing the fence wall inside the Gwadar is a manner purportedly aimed at the protecting unlawful mega projects and resulting in unlawful destruction and appropriation of the native property and other violations of rights of Baloch people is not proportionate or necessary. The fence wall in its present configuration violates Pakistan's obligation under international humanitarian law. The second part of the same topic is the growing recognition and protection of the rights of indigenous peoples to marine space and the marine resources under international human rights law. The prohibition of discrimination is fundamental principle of human rights enshrined in several treaties which Pakistan has ratified and is obliged to uphold, including the International Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant on Civil and Political Rights, and the International Covenant on the Economic, Social and Cultural Rights. In their present form, the fence wall and the accompanying restrictive measures imposed on the people of Gwadar, particularly native fishermen, are inherently discriminatory. They specifically target the poor fishermen and imposed restrictions on movement because they are Baloch in the enclaves mega projects which are now encircled by the fence wall. The restrictions on the movement or permit requirements are only imposed on native people of Gwadar and not on the other settlers who live in or visit the settlements in those areas. In this respect, coastal states are obliged not only to recognize the property of indigenous communities over traditional fishing grounds and marine resources in the same manner as non-indigenous peoples, but are also obliged to recognize such rights in a manner that respects the community's distinct way of traditional resource use and management system. In accordance with the evolved understanding of the right of non-discrimination, this understanding of non-discrimination requires states to recognize the use of traditional fishing and hunting methods, including the freedom to adopt such method to modern technologies. International human rights also provides procedural safeguards that oblige coastal states to consult in good faith and meaningfully engage coastal indigenous communities in all decision-making process related to marine space and marine resources, offering them in certain circumstances with respect to matters of fundamental importance of the survival, dignity and well-being of the indigenous people. Coastal states are required to obtain the free, prior and informed consent of the indigenous peoples concerned before taking any measures. The fourth part of the topic is the outcomes of such illegal fencing and forceful dispossession of indigenous people. The fencing of Gwadar violates international law in a several ways. Firstly, it restricts the Baloch people's access to their traditional lands and resources, contravening their rights under UNDRPP and ILO Convention 169. Secondly, it undermines the principle of self-determination as the Baloch people were not consulted or involved in the decision-making process. Finally, it threatens the culture heritage of the Baloch people who face displacement, dispossession, and demographic challenges. The fifth part of the topic is the instruments of international law and way forward. The international law, especially with the human rights framework, has now evolved in a manner that allows indigenous peoples to make claim over their traditional land, territories, and natural resources. I would like to read this again. International law, especially within the human rights framework, has now evolved in a manner that allows indigenous peoples to make claims over their traditional lands, territories, and natural resources. Since most indigenous peoples have limited opportunities to influence political developments in their favor at the national level, international level, or the regional or the geopolitical, they have increasingly used international human rights law and its judicial and compliant mechanism as important tools for their advancing their rights. Thus, the right to economic self-determination, the right to culture, the right to property, the right to equality and non-discrimination, as well as the right to consultation and participation, including free, prior and informed consent, have all been interpreted and applied in the resources. In this regard, the United Nations Human Rights Treaty, monitoring bodies and regional human rights courts and commissions, particularly the extensive jurisprudence of the Inter-American, African and human rights system, have played a significant role in the progressive interpretation and adaptation of general human rights norms. These developments in the international law clearly manifest the gradual decolonization of legal status of indigenous people by embracing indigenous people worldviews and recognizing their specific modalities and unique forms of land and natural resources uses. The international community must also hold Pakistan accountable for its obligation under international law. The last and not the least, the conclusion, which is also titled in the future, is ocean. The fencing, why Gwadar matters, why this fencing matters? Because the future is ocean. The fencing of Gwadar violates international law and undermines the rights of Baloch people. However, Baloch land is not a commodity which can be acquired but a material element to be enjoyed free. Thus, the people of Balochistan are entitled and gained clear recognition of their international legal personality and allows indigenous people to make claims over their traditional lands, territories and natural resources. Therefore, it should be clear from this forum that the people of Balochistan shall not let anyone, whether it is a person, government, state or any international political entity, to sell or mortgage the future which is Gwadar of Balochistan. The Pakistan government must reconsider and revoke the project and engage in meaningful consultation with the Baloch people to ensure their rights are respected and protected by international law. Thank you so much.